Sorry, okay. Corporate Affairs Commission, Alhaji Garba Abubakar. You're welcome, sir. The Chief Executive Officer of the Nigerian Economic Summit Group, represented by Mr. Nnanna Ude, who is a board member of the NESG and the CEO of Agon Continental. The chairman of the Nigerian Bar Association, section on business law, Dr. Adeoyo Adefulu. Panelists, moderator, distinguished ladies and gentlemen, I would like to welcome you to this webinar on the theme 2 years on strengthening CAMA 2020. Okay, so just a few housekeeping instructions. I'll expect that you would please keep your microphones on mute and your videos too, particularly if you are not speaking. And we would appreciate if you can just ensure that you do not cause any form of distractions, either until you're told to impute messages in the chat box. Thank you. So I'd like to just quickly introduce our panelists. NESG, could you please help us? Thank you. So my name is Nsikan Essien, and I'm the team lead Nassber operations at the NESG. So I'll start off with Alhaji Garba Abubakar, who is the Registrar General of the Corporate Affairs Commission. He was appointed the Registrar General on the 7th of January 2020. He obtained his law degree at the Ahmadu Bello University, Zaria in 1988 and was called to the bar in 1989. Until his appointment, he was the director in charge of compliance litigation at the CAC. He had earlier served as the special advisor to the former Registrar General between 2010 and 2017. In that position, he championed the reforms on ease of doing business, particularly in the areas of electronic registration, consolidation of registration forms, integration of the CAC registration portal with the FIRS stamp duty portal, reduction of registration fees, direct registration by first directors or subscribers, as well as the creation of public search window, which provides free information to the public on all entities registered by the CAC. He's also a member of the Financial Services Regulation Coordinating Committee, FSRCC, the National Steering Committee on Open Government Partnership, and the Governing Council of the NBA section on business law.
That was former.
Former. Oh, thank you so much, sir. And he has served on the governing boards of the Economic and Financial Crimes Commission and the Oil and Gas Free Zones Authority. He was involved in the design of some of the critical reforms in the corporate and financial sectors as a member of various committees. You're welcome, sir. We're pleased to have you on board.
Thank you for having me. Thank you. Thank you.
Okay, so a second panelist is Dr. Kubi Udofia, who is a partner with Babalakin & Co. Kubi is a seasoned dispute resolution and transactional lawyer. He's a partner at Babalakin & Co., a leading full-service law firm in Nigeria. Kubi is a leading and an acknowledged expert in corporate restructuring and insolvency law in Nigeria. As a scholar practitioner, he previously taught company and insolvency law at the University of Nottingham and was a visiting scholar at the Institute of Advanced Legal Studies, London. Kubi is the convener of Insolvency Discourse, a roundtable focused on the development of corporate restructuring and insolvency law and practice in Nigeria. He is a regular contributor in some of Nigeria's leading dailies, including This Day, The Guardian, and Business Day. His column, Insolvency Discourse in The Lawyer, a pullout in This Day newspaper, is the leading corporate restructuring and insolvency column in Nigeria. Kubi has a doctorate in law from the University of Nottingham, a master's in corporate law from University College London, the University of London, and a certificate with distinction from the Institute of Risk Management, London. Thank you very much, Dr. Kubi Udofia, for being here. Okay, so we also have here Miss Fire Williams. She is a certified international labor organization. She's a certified member of the International Labor Organization, Start and Improve Your Business Master Trainer, management consultant and founder, Simply Exponential Consults Limited, owners of Exponential Hub. She is a fellow of the International Management Consultants Board, FIMCB, the Director of Finance at the Innovation Support Network Hubs, and was a member, Ministry of Youth and Sports Development, Nigerian Youth Investment Fund Focal Group. She's also a fellow Institute of Safety Professionals and serves as director of a healthy and safety outfit with over 15 years experience managing a public-private enterprise and 30 years experience as an entrepreneur. She is an entrepreneurship consultant and business development service provider. Thank you very much, madam. You're welcome.
Thank you for having me. It's Mrs. Williams, though. Thank you.
Can we move on? Okay. So we also have on board Ms. Darin Adefulu. She is the executive head governance, Old Mutual Nigeria. She is an experienced business executive with expertise in regulatory compliance, corporate governance, corporate and commercial law, best practices and ethics, data privacy, stakeholder management, and company board secretarial matters. She has over 20 years corporate experience gained in various roles across different sectors. In her current role as the executive head of governance in Old Mutual Nigeria, she wears 3 hats as the Group General Counsel, Company Secretary, and Chief Compliance Officer. She provides in-country oversight and leadership in implementing the right compliance culture, drives adherence with the awareness of regulatory requirements, and she is the in-country money laundering reporting officer and regulatory liaison officer. Her career spans various in-house legal and compliance experience. She graduated in 1992 from the Queen's College London. She obtained her secondary education and also holds a first degree from Cardiff University and is a barrister and solicitor of the Nigerian Bar Association. We also have Ms. Bukola Bankole. She is a partner of TNP, an Anderson Global collaborating law firm in Nigeria. She leads the firm's corporate finance, capital markets, and technology teams. Her extensive and proven wealth of experience in advising on financing and investment deals cuts across various industries in multiple jurisdictions and aids her ability to always provide industry-specific expertise. We also have on board our moderator, who is Mrs. Ozofu Ogimida. She is a partner with Udo Doma and Bello Osagi, a corporate advisory, private equity, and mergers law firm. She is the co-head of the firm's pro bono practice, and she is the thematic lead of the regulations working group in Nassber. You're welcome, everyone. I would like to, at this point, invite for the opening remarks, Mr. Nana Ude, who is a board member of the NESG and the CEO of Argon Continental Limited. You're welcome, sir.
Thank you very much, Nsekaron. The Registrar General of the Corporate Affairs Commission, my brother, Alhaji Garba Abubakar, the Chairman of the MBA Section of Business Law, my brother, Dr. Adeoye Adefulu, who is ably represented here today, session resource persons, the moderator and panelists, session participants, ladies and gentlemen. It is my pleasure to welcome you on behalf of the board of the Nigerian Economic Summit Group to this event, which is themed 2 years on, Strengthening CAMA 2020. I wish to express our profound gratitude to you for making our time to join this conversation. Over the past years, the Nigerian Economic Summit Group has supported the reform of critical legislations towards improving the business environment and achieving global competitiveness. These efforts were made possible through a partnership between the Nigerian Economic Summit Group and the MBA Section on Business Law. to support the legislature through the National Assembly Business Environment Roundtable, Nassber. We have also extended that support to the state legislatures through the State Assembly's Business Environment Roundtable, SEBA, with the Conference of Speakers of State Legislatures. Through these platforms, we seek to support the creation of a conducive environment for nano, micro, small, medium, and large businesses to thrive by addressing existing bottlenecks that stifle business growth and economic development and eliminating them using legislative instruments. The Companies and Allied Matters Act 2020 is one such legislation. The review of the CAMA 1990 received a lot of attention by stakeholders who had patiently waited for the reform of the 30-year-old legislation. CAMA 2020 was envisaged to bridge the gap and introduce novel provisions to bring the law in tandem with current realities. CAMA 2020 introduced innovations for MSMEs, such as the single shareholder private company, limited liability partnerships, exemption from appointing auditors, and removal of mandatory appointment of company secretary from private companies. At this point, I must commend the Registrar General of CAC for his firm determination and support to unlock these reforms by pushing through this legislation. Thank you once again, Aji. After passage and assent, we committed as NESG to creating regular opportunities for stakeholder engagement in order to monitor progress, track implementation, and ensure impact. As you would expect, no legislation is assented in a perfect state. So it becomes imperative to strengthen it even while in operation. And so it is in this regard that Nassber held a webinar last year to deliberate on the implementation, impact, and challenges of CAMA 2020. We are here again today to further deliberate on critical interventions that will strengthen the law. I am glad that we have a distinguished panel of experts who possess the appropriate understanding, knowledge, and experience to point us in the right direction. And we have no better moderator for this session than my sister, Mrs. Osofu Ogemudia. The expected outcome from this event will be not only for stakeholders to have a better understanding of the dynamics of implementation of the CAMA 2020 and an appreciation of the critical role played by MSMEs in Nigeria's economy, but also to chart a path for practical reforms aimed at strengthening the Act through legislative, administrative, and regulatory measures. The NESG will continue to provide platforms to encourage public-private dialogue to tackle multidimensional challenges to economic growth in the national interest. I look forward to robust deliberations and use this opportunity to extend to you my compliments of this season. Once again, I welcome you and God bless Nigeria. Thank you.
Thank you very much, Mr. Ude. I would like to, at this point, invite our moderator, Mrs. Ogimide, to please begin. Thank you.
Good afternoon, everyone. Thank you very much for joining us on today's webinar, and welcome to all our distinguished panelists. We're already behind time, so I'm going to just run right into the business of the day. Starting with the RG, one of our panelists. I'm going to go to you first, sir. We're here to discuss, CAMA 2 years on. My first question for you today, sir, is reflecting on the past 2 years. There's no doubt that the CAC has been up and doing in formulating and implementing regulations, documentation, and processes to actualize the objectives of the CAMA 2020. What gains have you seen over the past 2 years with respect to the landscape provided by the CAMA 2020 compared with what obtained under the CAMA 1990?
Okay, thank you, Ozofu, and other distinguished panelists. As the agency responsible for implementing CAMA, I can say without fear of contradiction that the gains are too numerous to mention. We all knew where we are coming, we all know where we are coming from. CAMA 1990, which was amended or reenacted after 30 years. The legal framework is completely more or less different. You have simplified procedure for registration of companies and post-incorporation services because by the introduction of the use of electronic signatures for filings. You have the option of one-man company, although there is some misunderstanding on the one-man concept. We tend to forget that although the law allows you to register a one-man company, the same law says for a company that has been registered with more than one shareholder, one of the grounds for winding up of that company is if the membership falls below 2. So we need to balance this, and we have new insolvency regime under the new insolvency framework and the regulations that followed. Then we have things like lesser compliance burden for small companies. You don't have to have a secretary for a small company, a small private company. You don't have to have an auditor. And a lot of other measures have been introduced under the law that allows for greater transparency in the way in their dealings. And this is complemented with a new technological solution. The new company registration portal allows for end-to-end electronic filings, not just for new incorporation, but also for post-incorporation. Only recently, we have deployed an electronic financial reporting system that allows companies to submit their audited financial statements in extensible reporting language, which is the best practice globally. So, as I said, the benefits are too numerous, and these are just some of what has been done. And we expect that we are not the only beneficiaries, the companies are the greater beneficiaries. So I think the best person that will speak to the gains are some of the companies that are benefiting from the new law, the new initiatives contained in the new law. But as a regulator, as the agency responsible for incorporation, I can tell you that it takes less than a day to now incorporate a company. Because end to end, you get your certificate electronically when you submit your documents, provided all your documentation is in order, you get your result the same day. Some of the problem we used to have with names such as reservation, particularly restricted names, all these things have now been simplified. When you are applying for any restricted name, you don't need to send any email. You start and finish. The only thing you have to front load the information. And if the name is found to be okay, then you get approval almost the same day or a day after. So these are some of the gains of the new law. And but as we move along, as Inanna said, this law is not perfect. There are areas that will still need to be considered for review as we move along. Thank you for this. Thank you.
Thank you very much, sir. I think that lays the foundation for the rest of our discussion today. So I'm going to move quickly to Ms. Williams, who is going to be speaking from the point of view of the MSMEs. And for those of you that have followed the CAMA, you will know that CAMA has been heralded as a tool by which MSMEs will get the support that they need to launch their growth to the next level. So for Ms. Williams, my question is, how has this in practice been the experience of MSMEs?
Thank you very much, Madam Moderator Ozofu. I would also like to seize this opportunity to thank Alhaji Garba Abubakar for all the reforms, and thank you, sir, for being here. I hope the background noise is not distracting. Can you hear me?
I can hear you clearly, and I can't hear any interference.
Oh, great, awesome. So I would like to reiterate and confirm what Alhaji, the RG, just said, that yes, in some areas, there's greater ease of registration, the electronic portal, the requirements that you can have just one director, the cost saving, that you don't have to have a retainership, with the company secretary or employ one. Yes, those have been some gains. However, we need to remember that CAMA is sandwiched in between some other gatekeepers, so to say. So it's one thing that the MSMEs are able to get their companies registered, but as recently as this week, some female entrepreneurs, for instance, have not been able to open a bank account because they don't have SCUML. And SCUML is there, and then the FIRS is also there. So right now, we need to change the messaging to the SMEs to let them know what is in it for them. Let them know the benefits of registering a business, possibly open up opportunities, and let them know as well that if they're able to register their business, there should be some inter-agency discussion. I'm very grateful for this big tent stakeholders, meeting that we are having right now. This was also mentioned by Mr. Nana Ude, that there will be continuous engagement. Let there be inter-agency discussion so that we begin to remove the hurdles. Because Nigeria doesn't fare so well on the ease of doing business index. And I tell you that in spite of CAMA having a simplified process, some of the gatekeepers, the other regulatory agencies, they are still making it difficult for SMEs to fully embrace CAMA. So as of now, it's a situation of, when they ask us to come and register, it means they've gotten us. And the next thing is come and pay tax. So the messaging has to be clearer. It has to be more incentivized. We have to make it, beneficial for the MSMEs. The numbers are not appealing. 41 million SMEs registered according to, with the count from SMEDAN, but only 1,700 are small. And, very small numbers are actually in the formal sector. So I would say the MSMEs have not embraced it enough, because the messaging right now is, we've got you, come into the tax net. And when we've got you, we're going to slam on other regulatory affairs. So we need to see how we can begin to change that and make it more incentivized. If you pay early, if you do your annual returns early, maybe you're going to gain a 10% next year or something or the other. So that's just my initial thoughts.
Okay, thank you very much. So we've heard from the MSME perspective. Now let's go a bit larger to make the concerns that larger corporates are probably facing as they use the CAMA 2020. And I'm going to go to Bukola, who is a leading practitioner in the mergers and acquisition space. For you, Bukola, from authorized share capital to issued to mandatory preemptive rights for companies, there have been lots of laudable innovations in the CAMA 2020. Such as virtual AGMs, innovations around share buyback and treasury shares. But there are others that have been greeted with mixed reactions, and some have proved problematic. For instance, mandatory preemptive rights for all companies. Where do you see the biggest issues that require a revisit to the drawing board?
Thank you very much, Ozofu. And of course, Mrs. Williams and RG really indeed talked about, some of the beautiful things that have come out of CAMA 2020. And I like your question. You've also pointed out some of those issues, which, I would mention are those that have come out of, the CAMA 2020. The mandatory preemptive right provision, which you mentioned, is a very significant issue because it affects private companies, public companies. And it's not just about the inconvenience, right, that it poses. There's a lot of ripple effect. Investments are suffering. Where you have to, where your investors have to wait for you to do a rights issue, where you have tons of shareholders, it's a major problem. And what's different is, and what makes it even more inconvenient is bearing in mind that where we're coming from, that challenge was not there. So the idea and the expectation was CAMA 2020 did come to ease our burden, and why has it come up with these sort of provision and what can be done around it? Another of the issues RG did mention earlier, which is the issue around single shareholders, right? In one breath, everyone was excited, or a company can be formed with, a single shareholder. And a number of people here are practitioners and companies. And if you think back to it, in the previous dispensation, right, we were all saddled with, oh, okay, who is going to hold the second share in my company, who is going to be the second shareholder? So when this came, everyone was excited. And the rush to CAC began, only to get to the CAC and be hit by the brick wall. And this brick wall was, oh, well, sorry, you cannot, change from having two shareholders to having one shareholder. And initially, everyone thought, oh, wow, CAC is at it again. RG, forgive me for that one, but that CAC is at it again. But of course, they were pointed to the provision of the CAMA, right, which is in section 571, which identifies the fact that, it's a ground for winding up where a company with two shareholders fall with more than one shareholder falls to one shareholder. So the question is, what was really the intention around the law? It's a big challenge for people. It's a big challenge for the idea around, this CAMA has come here to sort of support all of those PEBEC initiatives and whatnot around the ease of doing business. Some of the other issues also revolve around clarity on a number of the provisions in the Act. There's also the question around transfer of shares, right, in private companies. Is this a mandatory thing? Is it optional? Is it, subject to your articles? But as currently drafted, right, there's room for various interpretations. So it's, concerns like that. And of course, I'm sure other people on this panel will talk about how it affects, their various constituencies, right? The issue around independent directors. There's also the issue around the removal of directors, which I found to be a very interesting one as well. We know there are certain situations where directors get removed. It could be because they could not locate them. The directors probably don't even know their shareholder, that they're still directors in those companies, and people have lost touch, and then they go through their processes and whatnot. And you remove that director. And we end up in the section in the CAMA that says you're automatically disqualified, from being a director of the company if you have been removed as a director in any company pursuant to, I believe that's section 288. So, it's a number of issues, right? Some big, some small, but these are some of the major issues, right, that people have been clamoring, for changes around. And it's exciting, that we're having this sort of conversations. We know the NESG, through the Nassber, we've written several papers, so for which you and the NESG team, have been championing and trying to find ways around some of this, working closely with the CAC. So yes, those challenges do exist, Uzofu. Well, while we're waiting for Ozofo to come back, I was trying to limit time. Ozofo, you're still muted. Maybe we can go to the issues around authorized share capital, several other issues, but
I cannot hear anything.
Mic back on. Okay, you're still muted on the other device.
Yes, sorry, I don't know what happened with my computer, so I'm on my phone, but I'm going to try and connect again on my laptop. Yeah, I was just about to say thank you, Bukola, because you led us to another issue when you mentioned the issue of independent directors. Darren, you pardon me because I don't have my questions in front of me, but I know that I was going to come to you to talk about what the CAMA has done in relation to corporate governance and, you know, some of the issues, good or bad, that it has thrown up. And but specifically, I wanted you know, to share your views on what CAMA has done in relation to independent directors, Section 274 services. So, Derek, over to
Thank you. Thanks all. So I note that the Registrar General and a number of my co-panelists have actually helped me in, you know, talking about some of these issues. But from my perspective, I work with a private limited company. I would speak about the issues about INEDs, independent directors. And even though that isn't such an issue in a private company, I'm speaking generally. So I would start with the point of the CAMA actually defining an independent director as a person who can hold, I believe, has a holding of not less than, not more than 30% holding in the company. And I just wonder about that definition.
I can't hear.
Can you all hear me?
Yes,
We can hear you loud and clear.
Here. So I just wonder about that definition in the sense that, is that really an independent director? And when you really juxtapose that with the provisions of the sectoral guidelines and of course the FRC code, which most of us have to adhere to. So for example, the NCC, the Nigerian Corporate Governance Code, defines an independent director as someone who should have minimal or no shareholding at all in a company. So there's some ambiguity there. I would suggest that some harmonization occurs, but I think most people just err on the side of caution in ensuring that they adhere to the stricter provision, but CAMA is the act. So I really think it's one to be looked at. And then I think the other issue, which is even more pressing and deals with the fact that public companies need to have a minimum of, I believe, is it section 274, 3 independent directors. And not all public companies basically want to be that huge or, you know, plan to be listed. So it seems a bit like a sort of sweeping brush and prescriptive. And humbly, we would suggest that it should be more principle-based. So a good example is the NCCG, the Corporate Governance Code, or the FRC code requires, I believe, you must have one INED and then a maximum of, or rather a majority of non-executive directors to executive directors. And so when you have the principles in place, the governance is there, as opposed to having a sweeping brush. The intent is clear and strong, but it creates a mischief for companies that cannot, for example, afford to have the 3 INEDs in as directors. Or, you know, how do we resolve that? So I would suggest that there is a need for more harmonization because we have multiple layers of governance. And I mean, the truth is we all just ensure to adhere to the most stringent rule, but it would really help if everyone speaks to some sort of harmony. I don't know if Ozofu is still there. Thank you.
Yes, I'm here. I'm almost back on my computer, but while I'm in transit, I'll go to Kubi next. So after many years of our corporate insolvency law being liquidation focused, Nigeria now has a formal corporate rescue legal framework under the CAMA 2020, particularly in relation to the introduction of the concepts of administration and company voluntary arrangements. So can you give an assessment of how effective or efficient these mechanisms have proven to be in restructuring failing companies? And are there any gaps or challenges that impair their efficiency?
Thank you very much, Ozofu, and thank you to NESG and Nassber for having me here. I believe it's still early days and we're still in what I would call the incubation period. So, I mean, CAMA 2020 was assented to law in, I think, August 2020. So it may be a bit too early to properly assess the efficiency or effectiveness of our new corporate restructuring tools. But aside, a typical CVA or administration may subsist for a period of 3 to 5 years. So let's say if we've had CVAs or administrations that have commenced, it may be a bit too early to, judge them or comment on the efficiency or effectiveness of the system. But be that as it may, I am aware that I think there is at least one administration which is ongoing, involving a company called Morehouse Company Limited. I think it was commenced sometime this year, July this year, and they haven't made much progress. I'm also aware that sometime last year, I believe in July 2021, Tourism Company of Nigeria, the owners of Federal Palace Hotel, also commenced the CBA. And I'm conversant with the details because they've made some filings in court. So although it's still ongoing, I mean, if you look at the CVA of TCN, you'd observe that there are a few gaps which the CVA has highlighted, which kind of shows that what we have, I mean, CAMA is commendable, the restructuring framework is commendable, but not perfect. So for instance, unfortunately or regrettably can I proceed? I can hear some noise at the background. Okay, so unfortunately for TCN, as at when the CVA process was commenced, the Insolvency Regulations 2022 were not issued. And also we do not have a proper practice direction to guide, to give or set out procedural steps which parties may follow in complying with CAMA. So I believe the promoters were left in a kind of some form of dilemma. So conventionally, practice directions are, issued by courts. So I'm not blaming the Registrar General or the CAC for the absence of practice direction. They are normally issued by courts, but in collaboration with the regulators. So they usually set out procedural steps for implementing or complying with a law. So for instance, in CVAs under CAMA, CAMA requires a professional supervising the process who is called the nominee. I'm trying to avoid using technical terms for the benefit of some of our attendees that may not be used to some of these technical terms for now. So the professional supervising CVA is expected to make certain reports to court. So it is the practice direction that will specify how these reports are to be submitted or made to the court, whether it is meant to be by a motion or originating summons or affidavit or by simple letter, and whether it is meant to be filed in a registry and then a suit number assigned, or whether you're just meant to dump, the process in the court. So these issues are not meant to be stipulated in CAMA. They are meant to be provided by practice direction or statements of insolvency practice. And that we don't have yet. So in the absence of the practice direction, and given that the regulations were not available then, the promoters of TCN CVA adopted the procedure in schemes of arrangement, the procedure set out for schemes of arrangement under Part 27 of CAMA. Schemes of arrangement have always been here. It's not strictly an insolvency procedure because you can use schemes of arrangement for your mergers and acquisition or any other transaction. The problem with this is that schemes require intensive court involvement or interference. You need to go to court, to order for a meeting to sanction your scheme after it's been approved by the meeting, and to even refer, even before it's being sanctioned, to refer it to maybe the Securities and Exchange Commission to scrutinize its fairness. But in contrast, the CVA, the idea behind the CVA is different. The CVA is meant to be informal, very flexible, with little or no court intervention unless it is challenged. That's the idea behind a CVA, to make it very simple for companies, especially SMEs, to take advantage in restructuring their debt. So what the promoters now did was to adopt the procedure for schemes of arrangement, which have been with us for a while, since the 1990 CAMA, to apply to their CVA in TCN. And because of this, and with profound respect to the promoters, TCN CVA, it makes it a somewhat poor precedent, even before its conclusion. It's ongoing, but these procedures, the defective procedures that have been followed, makes it a very bad precedent. So maybe I should leave TCN alone so it won't sound as if I'm being overcritical of that procedure. It was actually not entirely their fault. The fact is that we do not have a practice direction on ground yet, and the regulations, insolvency regulations, were not issued as at when it was commenced. But if you look at the CAMA itself, we do have other gaps and concerns when it comes to company restructuring. You know, one of them is still on CVAs. If you look at the provisions for CVA, CVA has to do with debt restructuring or repayment agreement between a company and its unsecured creditors. It does not provide for a moratorium or standstill mechanism. So CVAs, they are meant to be very useful restructuring tools for SMEs, but the efficiency may be impeded by lack of a moratorium because creditors may proceed to act even when the CVA is in process or when parties are trying to agree with the company about what to do to ensure that the company is restored to profitability. So a disgruntled creditor or a creditor who does not want to be part of, you know, the process may proceed to file a winding up petition, resort to the old liquidation that we're used to, or even go to court to enforce his rights, thereby frustrating the whole process. So I think one of the things we should consider, you know, in future law reforms is to insert a moratorium, a kind of standstill provision to ensure that once the process starts, creditors cannot take unilateral actions to frustrate the process. If you look at the United Kingdom's regime, previously they had a standstill or a moratorium for small companies. Now that has been replaced by a standalone moratorium, so companies can take advantage of that. And commendably, CAMA now provides a moratorium, though not automatic, for schemes of arrangement under Part 27. I think that's in section 717. And companies can take advantage of that. So such a moratorium can also be extended to companies undergoing CVAs. And lastly, I just want to also comment, one of the other concerns we're going to have, and which I think is not surmountable, is something that can be dealt with, is in the area of knowledge gap. We are in an uncharted territory. These procedures are still novel. And so the stakeholders would have to be properly, have to have this intensive training, sensitization, and education about the spirit and mechanics of these restructuring tools. You know, if I may be permitted, I'll just read a comment made by Honorable Justice Nnamdi Dingba in a webinar attended on CAMA 2020 last year. And this is even
I was about looking for the right play time to button in. So maybe after this, because I'm conscious of time.
Okay. So,
okay.
All right. So, okay, maybe I'll leave that for later. Thank you very much.
Thank you very
much. Do
much.
I just make this last point?
Yes,
just 2 or 3 lines.
Make the point.
Yes. So Justice Dingba made a comment. He said here, I'm reading from what he said. He said, it does not appear to me that we have quite sufficient critical mass of insolvency cases in Nigeria from which judges would have developed specialization. In this respect, all judges would appear to be learners and students of corporate insolvency. So that just highlights that knowledge gap and deficiency we have. Thank you very much.
Thank you so much. Thank you. Please, can our IT team mute participants that are not muted because there's some interference? Thank you. I'm moving back to the RG. And my next question focuses on the CAC's regulatory purview and some of the issues that have come up in relation to that. One of them relates to the powers of the CAC under Section 839 to suspend trustees. When CAMA was passed, I'm sure everybody on this in this meeting must have read some publication or article or the other about the concerns with this power, and there's even been some litigation about it. So regarding incorporated trustees, the issue has been widely discussed and the concerns have been raised. The other issue regarding the CAC's regulatory purview is the Administrative Proceedings Committee, which is meant to hear submissions regarding issues that users of the CAC service have with the commission. The concern is whether the constitution of the APC breaches the principles of natural justice. Because, for instance, the APC is supposed to provide an opportunity of being heard for persons alleged to have contravened the provisions of the Act or the regulations made under the Act, resolve disputes or grievances arising from the operations of the Act and the regulations, and impose administrative penalties. The APC is chaired by Mr. RG. There are 5 representatives of the CAC departments as members, and a director or high officer of the Federal Ministry of Trade and Industry. So I guess the concern is where you're alleged to have breached the CAMA or a regulation, we expect that the CAC will be the authority that is implementing or policing that, the breach and the consequences for those who have alleged to have breached it. But the committee that these alleged offenders appear is chaired by the RG and is essentially constituted by the CAC. And so people feel it will be difficult to have a fair hearing, because it seems like the one wielding the stick is also the adjudicator in this case. So I just wanted to hear from the RG on these 2 concerns, how it has played out over the past 2 years, and what can be done to allay the fears of the public. Thank you, sir.
Okay, thank you. On the first issue of Section F39, if you recall, that was a very hot topic when CAMA came into effect. And 2 associations actually took us to court. They have lost at the lower court. One of them has appealed. The issue is straightforward. The power of CAC to suspend trustees. Some have argued that why should that responsibility not be left to the members? But the truth is, most of these associations, there is no difference between the trustees and the members. Some are husband and wife, some are friends. Even when you think there is a general membership, the members on the record of CAC may not be more than 3, 4, 5 persons. And they hardly hold meetings. And the grounds for suspension are clearly stipulated in the Act. So, and since 2021, when we started this implementation, no trustee has been suspended. So most of the fears were actually overblown. The procedure for this suspension are clearly defined. We even tried in the regulations to provide more elaborate procedure to prevent any abuse. Even where CAC feels that somebody should be suspended, CAC cannot on its own suspend a trustee without recourse to the board of the commission and the Honorable Minister of Industry, Trade and Investment. So the powers of CAC to suspend is not absolute. So, and as we have said, there are similar provisions in other laws of other countries. Some of these associations are registered in those claims and they are not complaining. What it intends to do is to entrench accountability, because in the first instance, this money is not your money. You are a charity. Whatever income you generate, you are supposed to use it for the purpose of pursuing the objectives of the association. You are not supposed to share this money. But let's be truthful, how many of these organizations are actually accountable? How many? So if you leave it to them to do as they like, then the purpose will be defeated. So on this one, as I have said, one of the matters is at the Court of Appeal. We got judgment, favorable judgment in the lower court. And for us as a statutory body, we have a duty to be fair and just to everybody. Nobody will suspend you. You have to be heard. You are entitled to be heard, because under our regulations, to be suspended, you must even appear before the APC and be made to answer to the allegations against you. If the APC is satisfied that you have contravened or you are actually flouted some of the rules, then they have to recommend to the board of the commission. After the board has approved, the matter has to be referred to the Honorable Minister of Industry, Trade and Investment for approval before the suspension. So that is on trustees. On APC itself, the idea of APC actually arose from the informal process of resolving dispute that we've been doing in the last 15, 20 years, particularly for private companies we have very high incidence of sometimes surreptitious filings. You have instances where directors are removed without their knowledge or consent. New shareholders are inserted. Our records are actually doctored. Over time, we've been making inquiries. Sometimes we organize mediation meetings to inquire into these matters. We broker settlement between the parties. So we felt, let's formalize this process and document it such that it will be a record that a formal process has been carried out. But in drafting the law was made so wide as more or less to even assume a quasi-judicial status. In our regulations, we try to actually narrow this responsibility to issue of disputes as to the appointment of directors or shareholding, or issue of disputes regarding names. What we have is similar to what obtains under the ISA, Investment and Securities Act. The SEC has an administrative panel, administrative committee similar to what we have, which is chaired by the Director General with some of their officers as members. Nobody has complained about that. That same committee actually looked into the First Bank case and imposed penalties against the First Bank, Olonge versus First Bank case. And nobody complained. So I don't know why people are, it's only when it comes to CAC that, that everybody will be concerned. But unfortunately, because we do not have a board in place presently, the committee has not actually started functioning. So we're hoping that by the time the board is inaugurated, we have a lot of cases. In fact, lawyers are clamoring. A lot of lawyers have written to us. Some have even threatened to go to court as to why the committee has not been constituted. So if there is no visible value in what the committee is going to do, because it will simplify everything. The judicial process takes time, it's cumbersome, more costly. This is more or less at no cost other than the cost of transportation to the venue of the hearing. You don't need to incur any cost. And some of the processes may even be done all electronically. So if you are going to take your matters to court, it may and commercial matters, company matters, cannot wait for 3-4 years to be resolved. So this, I believe, is a fast track for resolution of some of these disputes. But if you look at our regulations, we have actually narrowed the scope of responsibilities of the APC. We don't want to go into the issues that should actually be handled by the court. So these are my thoughts on this. And you may have to excuse me, as I said.
Yes.
Yes,
Thank
I have another meeting. Yes. Thank you.
Thank you very much, sir. Thank you for sharing those thoughts.
Thank you. Thank you.
Okay.
Thank you.
So
Thank
I'll yes. Okay, I thought I was muted. Okay, so I'll go back to the MSMEs. Ms. Williams, what strategies in your view can be deployed to move a significant number of MSMEs from the informal to the formal sector? I ask because when you responded to the first question, I asked you pointed out the staggering statistics about 41 million SMEs and only 1 million of them in the formal sector.
71,000.
So
small and registered.
Yeah, so I mean, it seems like we still not bridge the gap that we've been hoping and talking about breaching for so many years. So what do you think needs to be done?
Thank you very much, Ozofu. I would honestly like to reiterate the fact that MSMEs contribute a whole lot of undocumented contribution to the GDP of the country. You know, about 90% of employment, about 50% of GDP, you know, is being contributed by MSMEs. So it really matters. And we need to do everything we can to cut them. So in a way, it might be that we may need to sell CAMA to MSMEs, you know, drumming those benefits again and again. And how do we do this? We look at how they are structured. So MSMEs normally belong to some business membership organization, some trade association, and these associations are taking their digital, they are creating a digital database of sorts. Now, states have also come in to participate. So I'll take the example of Lagos State. Lagos State is using LASRA the Lagos State, residence registration. They have a whole portal, and even those who pass through Lagos State Employment Trust Fund, which is established by an act, they must have a LASRA identification. So we need to begin to harness all these digital databases and have CAMA interact with them, tell them, oh, you are now a member of a BMO. If only you can take a step further to register your business, you may be tapping into the opportunity under the African Continental Free Trade Agreement to export your products to other African countries. We need to begin to tell them what's in it for them through their associations. So SMEDAN has a database. Ministry of Commerce, I have a huge fat directory right here in my office. There are databases of these MSMEs. CAMA needs to move closer to them because right now the gulf is like between Lagos and Kafanchan. CAMA, for instance, has about 870 chapters. There's no SME that is going to read that. They only need bite-sized information. And it was Dr. Udofia who spoke about a knowledge gap. You cannot begin to describe the knowledge gap with the MSMEs. It is huge. So we need to come closer to them. So another policy or another strategy that can work is for us to have representatives of CAMA in every local government for the 774 local governments. Look, in Lagos State, LSATF, again, the trust fund, they have an office in every local government and LCDA. And in those offices, it's not them say, I've been there myself. They speak the language the MSMEs understand. If they have to speak the dialect or vernacular, they speak it. And these people understand, and they tell you, feel this place, feel that place, because the RG, it's so nice to have electronic portal and all that, but there are so many digital, people that are digitally separated. In that case, they cannot use those portals. So another thing we can use to do to activate this is utilizing the hubs. I belong to a hub network of about 120, from Sokoto to Adamawa to Uyo to Bayelsa. We have hubs. Hubs are entrepreneur support organizations. They can be approached to help activate this drive. There must be a campaign. It will almost be like a COVID-19 awareness campaign. Get registered, get recognized. If you are registered, you can access funding. You can do better business. You can be recognized by the government. You can access grants and loans, So all this would go together to encourage the MSME to get registered. And there are also examples that have not worked. Like the MSME, you had one-stop shop at a certain time, but it was not sustainable. It was just like a flash in the pan. They would come to Lagos, go to the one stadium, be there for 3 days. In fact, some information that I got from the MSME, one-stop center, when I got to the regulatory body, they were asking me, how did you get that information? You're not supposed to be in custody of this information. So, again, there's that dichotomy, between the regulators and those they are meant to serve. So in summary, I would say CAMA needs to approach anybody or any agency that already has a digital database. Once there's some digital identity for these MSMEs, they should be encouraged, courted to take the next step to become registered businesses. And again, once they are registered businesses, all the benefits of being able to open a business account and operating it, especially with the cashless policy coming up, they should not be denied by other regulators who bring in other K-legs like the SCUMU and so on and so forth. So activation, campaign, changing the narrative, making sure the message sinks, and drumming in the what's in it for me would really help us to move the needle from 71,000 registered SMEs to a whole lot more out of the 41 nano, micro, small enterprises we have in the country. Thank you.
Thank you so much. I think your response has made it clear that, the plight or the situation of MSMEs, it goes far beyond CAMA. We need interagency cooperation. We need support at the highest levels. And so I hope the NESG representatives on the call are making notes, because I think after this, we need to find out how we workshop, this sort of feedback. I'll move on to move back to Bukola. Just going back to your earlier comments around the practical issues with the CAMA. There have been calls for clarification and amendments to enable CAMA function as the catalyst it's supposed to be. I know you've already touched on most, you actually mentioned a few when you were speaking earlier, but just maybe any other proposed amendments or issues you think could be fixed, either through regulation or an amendment to the law. What should we be angling for?
Okay, so thanks, Uzofo. When Mrs. Williams and Kobe were speaking earlier, they both mentioned something, and they've called it knowledge gap. I think from our perspective, right, what we can identify is there's a gap. So there's also the communication gap, right? Beyond all of these reforms, that we're clamoring for, and I mean, I'll go into a bit more detail regarding what the industry wants done, right? There's also the communication gap, we're coming from a dispensation where certain things, were being done. We're moving to a dispensation where things that were being done before are no longer being done. Reality remains MSMEs, different people, individuals, right, are expected. Now, take for instance, the issue around the transfer of shares. Reality is CAC used to accept documentation, right, regarding the transfer of shares. Let's forget the fact that it was not even under the CAMA 1990. We're all clear on that. However, there was a dispensation where you could file and your documents will be updated and your records at the CAC will be updated. So your bankers are expecting to see updated information from the CAC. Your investors are expecting to see updated information from the CAC. Now, these days, we just have to sort of explain and say stories. Frankly speaking, even some banks don't even accept, the stories we're speaking still, right? So the problem is, I think the CAC also needs to play an additional role, right, which is put communication out there, right, that allows these third parties understand why things have changed, or let them understand things have indeed, officially changed. So I think, those sort of initiatives and actions, by the CAC will be relevant and are indeed relevant. And then moving on to what's it called? Changes that need to be made. Some of it also, right, and I think it also involves the CAC maybe taking a softer approach, right, to some of the interpretation, right, of some of the provisions of CAMA. We've talked about these issues around single shareholders and whatnot. I think that also has to be that pause, right, and thought around, okay, if this is what Section 18 says, this is what 571 says, right, what exactly is the intention, right? Because we have two conflicting provisions. I mean, surely, let's look at it from a public policy perspective, right? And, or from a policy perspective generally, what were the drafters trying to achieve? Why were these reforms being done, right? So you're not giving it with one hand and taking it back with the other hand, right? So we think, the CAC does have a lot of work to do before we get to, the final page, right? Which is where these amendments are actually effective. So anyway, going to the amendments that we're looking to effect, one is these mandatory preemptive provisions in the CAMA. That definitely has to be revised to identify, right? It's not applicable to public companies on the one hand, and also to make the language softer to what we had before. It's quite cumbersome, right? Where you must do a rights issue. I don't think it takes away, right, from what CAMA is trying to protect if shareholders are still able to waive their rights. The current provisions do not give you that opportunity, right, to waive. So it's mandatory, you must go through a rights issue. And again, ease of doing business, right? So those amendments, Nassber, I'm glad you guys are here, NESG, those are very critical for the industry. Another point is on the transfer of shares. Frankly, that's mind-blowing, right? And even as lawyers, we argue amongst ourselves, right? Is it optional? Is it mandatory? The language has to be clear. If it's subject to the articles, then there shouldn't be a provision in the CAMA that says where you don't comply, you will no longer get the privileges accorded to a private company. I mean, the little joke is, what are the privileges for private companies anyway? But I mean, we can deal with that later. So, I mean, it's all of those little things. And there's also the issue around, you know, the minimum, your issued share capital. Granted, we have moved from a dispensation of authorized share capital to issued share capital. But the CAMA has been specific all along, right? So where it wasn't expressly stated, it's you know, it's a challenge where the first communication, again, we're back to communication that came out, is you must issue all of your shares. So public companies, private companies, everyone was scrambling to their lawyers saying, how are we going to issue all our shares? I mean, our shareholders are not trying to inject more money into the company. We are not trying to give up our shares, right, without consideration for them, right? So there was no communication. CAC simply said, issue all your shares. Now, there have been information passed that, oh, you can cancel the unissued shares by a resolution and whatnot. But I think the general sense is, these things are not written, you know, these things are not clear. It would be nice, you know, if our laws are clear and there's a process that people can follow, right? There's a process that we as lawyers can confidently advise our clients. I mean, we're working on transactions and you have to laugh and say, oh, let's just note it in there that waive your rights, your restrictions, right, on the transfer of shares, because we want to be safe. I mean, we're lawyers. We must be able to clearly articulate to clients, this is the position, that's not the position. But the CAMA 2020, in a number of instances, has left us, you know, playing, okay, maybe, maybe not, you know, not really making us sound confident or intelligent, frankly. So those things have to be addressed. Mozofu, I know you're pressed for time, so I will let you pass on to someone else.
Thank you. And just sorry, with apologies to the remaining speakers, I'm coming to you. But if you could please just try and keep it under 2 minutes, that would be much appreciated. So back to Dairy. You're the head of corporate governance in your organization. You have to direct the board and the organization on best practices and good governance. What are the tools, if any, that the CAMA has given you to do this, and what have you encountered along the way that you think needs, you know, a second look?
So from my perspective, the CAMA is like the basis, it's the act, and it has detailed provisions that basically ensure that, you know, companies adhere to best practices, corporate governance, and just, you know, right standards. You know, it's all encompassing directors, meetings, removal, directors' duties, auditors, audit committees. So, you know, it is all encompassing. Honestly, in terms of corporate governance, I would say that we look at the CAMA in conjunction with all other governance principles. So like the NCCG and the sectoral one. So we have, I work in a highly regulated industry, and guidelines by the insurance body is quite stringent. So I would highlight some wins though. You know, it's not all about maybe conflicts. It's quite gratifying for private companies to note that the CAMA, and even public companies to note that you can have e-meetings, and before there was some ambiguity, but that's clear now. And then of course the electronic processes, I think the Registrar General did a good job in you know, highlighting some of the wins in terms of what the CAMA 2020 does. And that has simplified processes, and I think that's a good one. And of course, Even though, yes, there is the fact that in private companies, there's no need for a company secretary. I guess it makes it easier for smaller companies, though there should be someone who handles that process. So generally, I'll just say that I wouldn't really highlight any major issues, but it's all about a multiplicity of governance requirements. And from my end, I would speak for more harmony. I think Bukola also said something that was pretty key in the sense that when you consult, the truth is we need consultation with the relevant bodies in the sense that, or rather in the sense that you might not know what the pressing issues are depending on the market. So it's very important that everyone's voice is heard. So, you know, we've heard from the MSMEs, we've heard from the corporates, we've heard from those who work in-house. And I think it's really key for that proper consultation to be had, because there were concerns in the past that the CAMA changes had a leaning towards maybe in-house issues. So I think I'll just pause there. Thank you.
Thank you very much. And thank you for keeping within our 2 minutes. So I'll go finally to Kubi, if I may. Just going back to all you've said about the company rescue procedures and the issues you've also flagged. For the purpose of law reform, what gaps and challenges which you had earlier identified would you regard as surmountable, i.e. we can deal with them? And how do you think from a practical perspective we can go about dealing with this, especially when you consider that you know, law reform is a long process. We're about to move from our current National Assembly to another one. We have elections. So, you know, it's easy to talk about amending an act, but in practice, it could be years, you know, in the making. So from a practical perspective, is there a way to quickly address some of the issues you've identified?
Yeah, thank you very much. Like I typed out in the box, the challenges are actually surmountable, and that's a consolation we have. So yes, and like you rightly said, law reform amendments is not really a low-hanging fruit. So in terms of the moratorium I pointed out in CVAs, what transaction parties can do, though it's a difficult one, is to try and agree on a form of standstill arrangement. If unsecured creditors could come together before commencing the process, and then they have a standstill agreement, like a contract, that parties would not take unilateral steps, would not file winding up petition or resort to liquidation while they are negotiating and before an approval is made. Because once an approval is made, it becomes binding, whether creditors agree or not. It binds everyone. But the problem is, before that approval is made at the meetings. So parties can try to have that standstill contract, which would be binding and kind of enforceable. So if someone reneges, he could go to and decides to go to court, he could raise an objection in court and draw the attention of the court to the fact that the creditor had entered into an agreement not to do anything pending when the CVA process is completed. And I did point out other gaps, for instance, the absence of practice direction and procedural guidelines. So the good news is that, you know, at our own level in BRIPAN, Business Recovery and Insolvency Practitioners Association of Nigeria, we're working on drafts because we're not waiting for the courts, you know, to do what they're supposed to do. So we're taking the initiative. Already we are dealing with drafts of practice directions for the Federal High Court, Court of Appeal, and the Supreme Court. Incidentally, I chair the committee, the drafting committee for the Federal High Court, which is about the most important of the practice directions. So the target is by January next year, 2023, we're going to have a meeting with the leadership of the different courts, and we'll submit the practice directions to them so they can issue them and they'll come to force, into force. Then lastly, on the issue of knowledge deficit or knowledge gap, I mean, it's a one-way thing. The simple solution is that there has to be intensive sensitization training workshops and programs for the major stakeholders, judiciary, the regulators, and then the practitioners. Thank you very much.
Thank you very much. I think with that, I have come to the end of my specific questions for each panelist. So I'm going to go to one final question, same question I'm going to put to everyone. I have, from the corner of my eye, just checked. I don't think I can see any questions, but Insi can let me know if I overlooked anything. But while we're waiting to see if there are any questions that I can put to the panelists, I'm going to go around, just sweep the room, the panel, and ask if there was one thing you could change in the CAMA 2020, what would it be? Let me start with Ms. Williams, Mrs. Williams. Yeah.
One thing.
Just one thing. So
one
you had your
thing.
wish. Yes.
The fact that you make annual returns to CAMA and you also have to make to other agencies, that's a no-no for me. It should be, we should remove the multiplicity and just have one set of returns. Whether it's CAMA, whether it's FIRS, they should decide. Thank you.
Oh, thank you. I like that. To the point. Bukola, what's your one thing out of the 100 things you want to change?
That's the problem, Oliver Twist. So I will actually leave that question because I know the rest of the panel, will answer that. I'm really sad the RG is not here. The one question I have for him, and which we also need to think about as a group, is this issue around the CAC now saying that the NIN is going to be the mandatory form of identification. I think it's a fundamental issue that he should have been here to sort of tell us the rationale, behind it. So the industry understands, because right now it doesn't make sense to any of us. This is going to pose a problem for a whole lot of people and a whole lot of reasons, right? What are foreigners supposed to do? Does that then not defeat the issue around, oh, you want to use the NIN, since you're saying maybe foreigners, or you can register in various countries, right? We want to make sense of it. The CAC is the custodian of the CAMA 2020, and a lot of these issues are posing challenges for us. So Ozofo, NESG, please take our question back. The industry wants answers, and we are trusting you to come back to us with something.
Okay, Daring.
Thank you. So mine is an interesting one. I would just, it's not so much CAMA, more the CAC. I think that we need a robust strategy. What I mean is, talking from my own selfish perspective, I work in a multinational, and we have situations where checks are made online, and documentation or evidence online doesn't actually tally with what actually the actual filings are. And, people abroad cannot come to obtain CTCs. So I would really suggest, and I hope that this feedback will get back to the Registrar General, that we have a robust e-strategy. The website is updated. More things can be done. More searches can be made in real time by anybody. It helps promote transparency and actually would give validation and make other agencies see the value of pushing a robust e-strategy, simply because that's the way of the future. And yeah, that's my own suggestion.
Thank you. And Kubi, I'm not sure I've come to you, right?
No, I haven't said anything yet.
Yeah.
I should have the last say. Okay, so I would introduce a moratorium for companies undergoing voluntary arrangements to ensure that the procedure is not disrupted by individual actions by some disgruntled creditors. Because I believe with this, it will be absolutely beneficial for SMEs who opt to use the CVA, to restructure their debt. Thank you.
Oh, thank you very much. Okay, so in the absence of any additional questions, I think we have miraculously kept to time and come to the end of our discussion. Thank you so much, panel, and thank you to everyone that has stayed with us. So I think I'll hand back to Insikan, and she will direct the closing remarks.
All right, thank you so much, Zofa. That was wonderful. I would just like to invite Mr. Babashola Alokolara, who is the Secretary, NBA SBL.
Alokolaro.
Oh, sorry, Alokolaro. Please forgive me for that error. I hope he's on the call. Oh, yes, he
I'm
is.
right here. Ozofo, I don't know why you're feeling cool for pronouncing the name wrongly. It's Alokolaro Edo Line. I don't understand. You're my sister from UUPO.
Yeah, years of living in the West, I've learned to pronounce things.
All the years of Queen's College, but it's okay. It's all.
Yes.
RG, unfortunately, you're not here, but I'm sure you're ably represented. Thank you, Amelia, for standing firm, standing still. It's not an easy task dealing with these lot. Specifically, I must say, my partner has been on this call. The views she's expressed are expressly hers. I don't represent the views of my firm. I heard her challenging you. That's not TMP's position. That's Bukola Bankole's position. So if she leaves TMP any day, she goes with that position. If she doesn't, it still remains her position. But RG, I say a million thank yous to you. More so because you have been an RG that is not just receptive to ideas, but extremely responsive. I have called you a couple of times without you knowing who was calling on the other line. You've responded on issues even when you were not a member of council of the SBL. There should have been two doctors on this call. One is Dr. Adeoye Adefulu. Maybe he didn't want to, the academics and the intelligentsia, they're consistently, what's that word again? Consistently, not combative, but they're competitive. So maybe he didn't want to be on the call with the Dr. Kubi Udofia. And so he sent me, and perhaps he didn't want to be on a call with the Mrs. Adefulu, and so there won't be two Adefulus. But one thing in the Adefulu family that we have in common is the name Babashola, which is my full name, and that's their son's name. So they Adefulu of oldest repute and old mutual who I've known for over 30 years. It's fantastic to have you on this call. Mrs. Fire Williams, it's a pleasure to meet you and to have heard your views, and for you to have aired your views, and to also have challenged the system. Truly, we're work in progress, and we will get there. When I started practicing law, we were working with a company act or a company law that was outdated as at its time. Beyond its dating, we've moved, and we'll keep on moving. And it has now become our role and responsibility to consistently move the needle to make sure that our company law is fit for purpose and tailor-made to respond and to be prepared for the transactions that we all handle. It's not an easy job. When Doye called me and said he would like me to represent him on this call, I was like, okay. I looked at the panelists and I said, it almost seems like it's all an SBL panel. And truly, it just shows that SBL is moving in the right direction. I saw when Toyin Bashir signed in, and Toyin Bashir, Ozofu, Jumoke Oduwole, these are people that truly were instrumental to the passing of the I still call it the new CAMA, but we call it the CAMA 2020. But in the last 2 years, truly have not existed and not real. So for me, it's still the new CAMA. And as such, working with people like the RG and co, you brought us a law that it may not be where it should be, but will ultimately get us there in the shortest and soonest foreseeable future. And I thank you all. For all the panelists, if I haven't called your names, I know I mentioned Dr. Kubi Udofia, I mentioned Bukola Bankole and said that her views are hers. Ozofiu Ogemudia, my sister Edo Line, who's the moderator. And because we're working on this call virtually, I have to start looking for names. Mrs. Williams, thank you so much again. Deering, yes, I mentioned already, 30 years plus. Mr. Nana Udi, again, thank you for your opening remarks and for making this happen and for setting the pace at which we've moved on. In SICAN, SCN from NESG, NESG has been a body that has been charting the course for which is moving and able to move this country forward in terms of our policies and particularly economic policies. And I thank you all for, within that group for setting the pace on how we're moving forward in Nigeria. On behalf of the SBL, specifically my chairman, Dr. Dioye, before I call him Derin, Adefulu, I thank you all for this opportunity. And unfortunately, he couldn't be here because he's locked down on Nigerian Bar Association Executive Council meeting, and he couldn't be here. And please, I extend his apologies and thank you once again for the opportunity and for the soundboard and what we've heard today and for the experts that have been on this call. Tony Abdul, if you're Tony Bashir, if you're still here, thank you, with Ozofu, for giving us the new law. Thank you very much.
Okay, thank you very much. Thank you very much, Mr. Alokolaro. I got it right this time. Okay, so I would just like to thank everyone for joining on, and I would like to, at this point, say we've come to the end of this webinar. And if you have further questions you would like to raise, please reach out to us. That's the Nassber Secretariat at nesggroup.org, or you just check us out on the website www.nassber.com. Thank you very much. So from my end, it is goodbye to everyone. Thank you. Thank you.
Thank you. Bye-bye.
Thank you.
Goodbye. Thank you.
Thank you, everyone.
Goodbye.
Also, I'm calling you now.
Yeah, I was about to call you.